Penny Clark, Darling River Group, Whitecliffs Branch Delegate, member number 126755, formally moving the motion.
Annette Turner, past date President, Whitecliffs Branch, Darling River Group, 111027. I formally second this motion.
Madam Chair, Resources and Geoscience licenses companies to undertake mineral exploration in New South Wales. Current policies enable $2 companies to be licensed. Once licensed, these companies approach farmers to gain access to their land. Farmers, whilst not against mineral exploration, become entitled to both the recovery of legal costs and compensation for any damages incurred. They do this through negotiating a land access agreement. These access agreements are complex legal documents required under the Mining Act 1992. Farmers as family businesses are inherently disadvantaged in understanding and negotiating these documents, but they are required to under New South Wales legislation. Resources and Geoscience do not adequately assess the capacity of exploration companies to pay any compensation due to the landholder. At this stage, they say it is a commercial agreement between the parties, despite there being a government-imposed legal process if agreement cannot be reached. The majority of exploration leaseholders are $2 companies with limited liability. This means that their structure is designed to protect the individuals who own the company from any financial risk. They have invested $2. This structure means that in the event of any compensation being due or legal proceedings, they can fold or bankrupt the company and no money can be paid out as there isn't any. This structure poses massive risk to family farms. Their stock and land can be damaged and destroyed, but their right to compensation has been negated. Farmers are assuming all the financial risks on behalf of explorers and the government. This is an unacceptable situation. Increasingly, even larger mining companies are using these structures and complex identities to be able to undertake exploration on farmland with zero risk to themselves. If farmers refuse to sign these agreements under the Mining Act 1992, the explorer has the right to mediation, arbitration and Land and Environment Court proceedings. The $2 company structure, once again, denies farmers guaranteed access to repayment. If they can't or won't pay the cost required under the Act, they can simply close down the company and the individuals and directors who initiated the legal proceedings are free from the debt. This situation substantially disadvantages landholders and farming families and essentially holds farmers hostage as they cannot bear the costs themselves. We are seeking to lobby government to re-establish the rights of landholders to compensation and costs that have been eroded by the company structures of exploration companies.
The website of the Australian Securities and Investment Commission gives this advice. A $2 company is not necessarily a bad risk, but $2 may be all the members have to put in a fund, a company's operations. The amount that members are willing to invest suggests how much risk they are willing to accept in backing the business. In terms of exploration licences, there is a precedent in case law. In August 2009, Commissioners Moore and Dixon handed down a decision in the Land and Environment Court which granted an explorer access to land. I have replaced the name of the company with the general term $2 company, and I quote, "We require that all directors of $2 company give personal guarantees for any liabilities the company might incur under its access. We therefore require such undertakings by each of the directors of the company are to be filed and served within 28 days. The access arrangement is not to commence until after these guarantees have been filed and served." The court had decided that the landholders had valid reason to be wary of the $2 companies. This decision is over 10 years old, and yet the landholders in 2021 are still being approached by $2 companies licensed to explore on their land. We all shouldn't have to go to court to be protected. In December 2020 publication, Mineral Prospecting Minimum Standards, the New South Wales Department of Planning, Resources and Geosciences admit under the financial capacity section, given the highly speculative and results-based nature of mineral exploration, various factors can directly influence an authority holder's finances. Currently, under resource speculative $2 exploration, companies have extraordinary power to access agricultural land. They have the potential to cause economic harm to the landholders because they may be unable to fulfil their obligation to pay compensation and legal fee reimbursement. We propose that the CWA of New South Wales should agree with Assoc and the Commissioners in the Land and Environment Court that the $2 companies are a risk and to lobby for this licensing to cease. Thank you.
Microphone 3.
Anna Christie, member number 127229, Maules Creek Branch, Namoy Group. This is a very succinctly phrased motion, and it's hard to believe that anyone might vote against it. I just wanted to point out that this is part of a larger problem, a problem of lack of regulatory oversight of the mining rehabilitation generally, and this links with some recent advocacy that's been conducted by our organisation concerning the hydraulic fracturing plans out near Ivanhoe. In 2017, the Land reported that tight sands gas extraction using the controversial hydraulic fracturing or fracturing method was being targeted by a company called Paradigm Resources. The ASIC register now lists this company as being under administration, which seems to point to insolvency. I'd also like to point out that once a project like this might be approved and conditioned, the New South Wales Audit Office did a report in 2017 stating that while there have been substantial increases in total security deposits held, mine rehabilitation deposits are not likely to be sufficient to cover the full costs of each miner's rehabilitation in the event of a default. So I fully support this and endorse this motion, and any work that can be done in advocacy, which obviously is currently being undertaken in relation to the fracking intentions out in far west New South Wales, that these discussions be had. So thank you for raising this White Cliffs, and I endorse this motion.
Microphone 2.
Thank you, Madam Chair. Wendy Morris, Wungarbin Branch, Macquarie Group, number 111188. I really would like to commend this motion to all delegates here today. That is an outstanding motion. It is something we really need to engage with, to really push, to see our rural communities, our farming families, the women and the children that are impacted by these $2 companies is just unbelievable. The emotional and mental stress, which then becomes a financial stress, is just so unnecessary, and yet it's out there day to day, not knowing what's going to happen on your land, under your land, and this constant knocking at your door, making a phone call. We would like to engage and do this on your property. It's just so difficult. And again, thank you so much for bringing this motion, and my heart goes out to the people who are impacted daily by these particular companies. So please, I would like to really support this motion. Thank you.
Any other speakers? All those in favour? Against? So that is carried.